We're going to take a tour through the basics of civil law in England and Wales. First things first, civil law is all about sorting out disagreements between people, businesses or organisations. And like criminal law, it's not about punishing crimes, but about making things fair when someone's been wronged. So what happens if you win a civil case? The court's main aim is justice through fairness, not punishment. So the main remedies will be compensation, usually money paid to cover damage or loss, injunctions where the court orders tell someone to stop doing something or to do something. And then we've also got declarations, which are official statements about someone's legal rights. Civil courts are set up in a hierarchy, and that means simple cases start at the bottom and the bigger, more complicated ones go to the higher courts. Let's start with county court, and most civil cases will begin here. The county court has different tracks depending on how much money is involved and how complex the case is. So let's take a closer look. We've got small claims track, and this is for cases up to £10,000 or £1,000 if it's about injury or housing. It's an informal, quick process, and you often don't need a lawyer. Then we have fast track cases, and these are for cases between £10,000 and £25,000. These should finish in a single day, hence the name fast track. And then we have multi-track for cases over £25,000 or especially complicated ones, and these are more flexible and managed by a judge. Moving on to the High Court now. So the High Court is going to be dealing with big or more complicated cases and is actually split into 3 divisions. So to start with, you've got the King's Bench, which handles contract, tort, wrongs like negligence, personal injury and defamation. Then we have the Chancery, which deals with business, land, trusts and insolvency. And finally, family, which deals with more serious family matters, especially international or high-value disputes. Sometimes if a case is really important, it can leapfrog straight from the county court to the High Court. Appeals. So appeals are when you ask a higher court to check on a decision. And the usual route is that county court will appeal to High Court, High Court will appeal to Court of Appeal, Civil Division, and Court of Appeal will then appeal to Supreme Court, but only if it's about a very important legal point. There's also something called a leapfrog appeal under the Administration of Justice Act 1969, which lets some big cases jump straight from the High Court to the Supreme Court if there's a major public issue at stake. In terms of evaluation, well, appeals are essential. They help keep the system fair and consistent, but they can be rather slow and expensive. Civil procedure and the Woolf reforms. Before 1999, civil justice had been criticised for being very slow, costly and confusing. And Lord Woolf changed all that with the Civil Procedure Rules 1998, or CPR. So the main aims were to simplify and unify the rules, reduce costs and delays, encourage fairness and proportionality, to promote ADR, alternative dispute resolution, take a closer look at that in a moment, and to get judges to actively manage cases, not just watch from the sidelines. The core idea is the overriding objective, CPR Part 1. Handle cases fairly, justly, efficiently and proportionately. Later on, the Jackson Review in 2010 tightened up controls over costs, and this shows that civil law is always changing and improving. Let's take a little bit of a closer look at ADR now. So ADR means ways of settling disagreements without going to court. It's always the better option after all. The CPR encourages this, and there are 3 main types. The first is mediation, so a neutral person helps both sides talk things through. It's cheap, it's quick and it's private, and it helps keep relationships friendly, but it's not legally binding. Then we have arbitration, which is where an independent arbitrator will hear both sides and give a binding decision. So it's flexible, it's confidential, but it can get expensive if the case is rather complicated. And then we also have negotiation, in which the parties talk directly to each other. This is going to be the fastest route and also the cheapest option too, but it's only going to work if both sides are willing to cooperate. ADR is great for saving time and money, but if someone refuses to play ball, then of course it might not work. Sanctions. Now, judges have some strong powers, thankfully, to keep cases moving and to deal with those who break the rules. Here's some sanctions, and we start with cost order or costs order. So this means making one side pay the other's wasted costs. You've also got something called a strikeout, which is basically throwing out a claim or defence for a serious failure. Then you've got an unless order. Basically means do this by a certain date or you're going to face a penalty. And finally, we have adverse order, which is stopping a party from using certain evidence, taking away that right. This is going to keep these rules keep this system fair and efficient, but of course they can disadvantage people if they don't have a lawyer. The Briggs Review and modern developments. So Briggs said civil justice was still too slow, costly and pretty hard to access, especially for small claims, and he suggested creating an online court for small claims. And this would mean simplified digital case management, better help for people without lawyers as well. Now, during COVID-19, the courts adapted by holding remote hearings over video or phone and let people file cases online using Nightingale courts in public buildings. This was good in that these changes made the system much more flexible. However, you could also argue that it was bad because some people struggled with digital exclusion. After all, not everyone has access to technology or is very good at using it. Juries. Well, civil juries are now very rare. Under Section 69 of the Senior Courts Act 1981, they're only going to be used for special cases like false imprisonment, malicious prosecution or fraud. Here's a couple of cases to know. You've got Ward versus James in 1966. This case decided that personal injury cases are handled by judges and not juries unless there are very special reasons. This is to keep decisions fair and to keep the costs down. We've also got Singh versus the London Underground and H versus Ministry of Defence. This confirmed the rule from the previous case. In terms of evaluation then, well, juries mean public participation, which is good, but of course judges are going to be quicker, aren't they? They're also going to be more consistent and finally cheaper too. Let's take a look at tribunals now in civil justice. So what are tribunals? Well, they're a bit like mini courts for certain types of disputes, and they're cheaper, quicker and less formal than the courts that we've talked about. The main types are administrative, for example, for immigration, tax, social security. Then we have employment tribunals, which is for things like unfair dismissal or discrimination. And finally, domestic. And this could be professional or club discipline. Some major reforms came in the forms of the Franks Report from 1957, which said that tribunals should be open, fair and impartial, rightly so. We've also got the Legat Review in 2001, and this said tribunals were rather messy and confusing. It suggested putting them all into one system, which would make things simpler and fairer for everyone. And then we have the Tribunals, Courts and Enforcement Act 2007, which created the first tier tribunal, main hearings, and upper tribunal, appeals. Evaluation then, well, tribunals are specialist, affordable and reduce court pressure, but they may seem a bit less formal and maybe even inconsistent. Here are some very important cases and laws to remember. So it's important to take some time to review these and make sure that you are familiar with each of them by doing your own research. And we've also there got some statutes that it is important to learn about as well, which we've mentioned as we've gone along. And that's a pretty quick journey through civil law. So if you remember the main court structures, what remedies are available and where ADR and tribunals fit in, well, you're well on your way to understanding this topic. Thank you.